So I'm delighted to introduce the Ethics Conference 2021, which has been sponsored by the Clark Foundation. The Clark Foundation is a charity which promotes the law of Scotland through legal education and training. And thank you to the foundation and our contact Lucy Thornton, who is also a past president of SYLA, for their assistance in the lead up to the event. Sorry, just to say, other people joining the meeting, if you could just mute your microphones, please, and maybe turn off your cameras. Perhaps if the speakers could maybe mute themselves at the moment as well, please, just in case it's them. So I've been really looking forward to our conference, particularly given the interest gauged from our social media polls last summer. We do have three fantastic speakers today, Stephen McLaren, Ian Sim and Susan Williams. As ever, please do type any questions into the chat box, which should be on the right-hand side of your screen, and we'll get to those at the end. We will also send feedback forms after the event, or also please do get in touch via any social media channels with any comments. So first of all, I'd just like to introduce our first speaker, who is Stephen McLaren. He's a Senior Associate at Leddy & Chalmers and also a tutor on professional ethics at Robert Gordon's University. So over to you, please, Stephen. And again, just a reminder, if people can mute their microphones, just because I think there's still some feedback. Thank you.
Okay, thanks very much, Leila. Good evening, everyone. As Leila said, I'm a tutor at the professional ethics at Robert Gordon's University. And I think mainly for that reason, Leila had asked if I could just provide some general information regarding these Solicitor Practice Rule 2011, and also more specifically the 15 Standards of Conduct. That seemed to be something quite a lot of people were interested in, or possibly have a lot of information about. So what I'd like to do is that there's a lot obviously in that to unpack, and I'm going to start off just by doing a very brief rundown of what the practice rules are about, and then move on to the 15 Standards of Conduct and try and give you some examples that I've come across in my experience that might help understand these standards a bit better in practice. So the Solicitor Practice Rules 2011, I say they cover the 15 Standards of Conduct, but they also cover issues with services and specialities. For example, if you're a solicitor advocate, there are certain rules within the practice rules which tell you how you need to perform and conduct and service advocate. The most important thing to note about the solicitor's practice rules, from your point of view, is that a failure to adhere to the rules will be considered professional misconduct or unsatisfactory professional conduct. Hopefully you'll have picked up from your ethics courses at the diploma, and certainly through the Robert Gordon ones anyway, that professional misconduct is the worst, essentially, offence you can be charged with in terms of conduct charges. The effect of being found guilty of a professional misconduct charge could be that you are struck off. Sorry, I'm just seeing some chance of feedback. Is it getting any better? Hopefully. Okay. Yeah, so the other thing you be charged of is unsatisfactory professional conduct, which is still bad, but generally at the lower end of the scale. And if you're found guilty of that, it's less likely to result in catastrophic consequences for your career. But it is important that essentially a breach of a rule could lead to bad consequences for you in your career. Okay, so the 15 Standards of Conduct, then, I mean, I'll rattle through these very quickly. You can actually find the detail of these on the Law Society website under the Rules section. But essentially, the 15 are trust and personal integrity, independence, interests of the client, proper instructions, confidentiality, conflict of interest, disclosure of interest, effective communication, competence, diligence, and appropriate skills, professional fees, withdrawing from acting if instructions are accepted, relations with the courts, relations between regulated persons, diversity, and duty to cooperate with the society. So, as I said, the plan is to go over each of these, not in any detail at all, because we've only got about 15-20 minutes for this, but just to give you some examples as to how I think these might apply in practice to you. Leila, sorry, before I get started, there's quite a lot of folks saying there's kind of audio issues. Do you know if that's any better? No?
Yeah, so Yeah, so if you're calling in just from your phone, could you perhaps press mute? Imagine most people will probably have iPhones, so there is an option there, or on other phones. Or if you do have a lot of background noise, could you perhaps try and see if you could join via a laptop instead, please? Um, just make sure that you're on mute, please. Sorry, Stephen, maybe try
No,
again now.
no, that's fine. I mean, if you can hear me fine, hopefully the recording will be
Anyone else?
okay from that point of view. So if
Yeah,
anyone misses anything, they could pick up on the recording as well.
perfect.
Okay, great. So the first one in terms of this is just going by the order they are on Law Society rules, and it's trust and personal integrity. Now, this is the big catch-all, and hopefully will be relatively obvious to everyone. It's just all about mainly keeping your word. Aside from anything else, it's good for your career if you're regarded as someone who can be trusted, as well as being something which obviously keeps you right with the Law Society. Next one is independence. Now, what this really means is that when you're giving advice to clients or when you're acting on their instructions, you are doing so free from any external influences. So you're not being affected by the fact that someone's putting pressure on you for a certain outcome. And also, in my view, what it would be quite useful for you to understand from practice is that sometimes you have to understand you have to deliver unwelcome news to clients, usually for hopefully for their own good. But sometimes you can't be a yes man. You have to tell them what your advice is, however unpalatable it might be. And I view that as an element of independence as well. Next one is interest of the client. So, and clearly this is fairly important as well. In most circumstances, the interests of the client and you upholding those will be the most important interests that you are supposed to adhere to. Sometimes these interests will conflict with other responsibilities, such as the responsibility you might have to the courts, responsibilities you might have to other parties or other professional colleagues. But generally, the responsibility of doing the best for your client will be the paramount responsibility. Next one is proper instructions. So this is just to make sure that the client has to understand what they are asking you to do. So if they have capacity issues due to age or illness, then that might affect your ability to obtain proper instructions from them. So you need to know and be aware of that possibility when a client comes to you for advice. You could also just be making sure they understand your advice before giving your instructions. And really, what that comes down to sometimes is that obviously, when we're giving advice to people, quite often the people we're giving advice to don't have any legal background. And so you have to make it so that your legal jargon is understood by them so that they know what it is they're actually asking you to do. So that's going to be quite important as well, because if they give you instructions based on a misunderstanding of what your advice is, then that's just as bad as them having capacity issues and being unable to understand or give instructions properly. The next two standards of conduct are really what you'd say the big ones, which are confidentiality and conflict of interest. These are the ones which are very specific. Everyone knows about the confidentiality responsibilities that lawyers have. Um, you've got the duty to keep information which you receive in a solicitor-client relationship confidential. Sometimes that can be waived by the client giving you a waiver, and sometimes other legal responsibilities, such as proceeds of crime provisions, might override those duties of confidentiality as well. The conflict of interest, again, is one of the big ones, and the main issue with that nowadays, this makes me seem really old, is that it's an interconnected world, and there's so much interconnectivity between clients, and so there's much higher chance for you to end up in a situation that oh, sorry, someone said, sorry, Heather, there's no slides for this one. It's just me talking, unfortunately. So, yeah, so, and to organize against conflict of interest, you have to make sure that there are systems in place to flag up potential conflicts before they occur. And again, there are exceptions, as there usually are in a lot of these things, with, for example, conveyancing. In conveyancing transactions, you can sometimes act for the buyer and seller, providing there are a certain circumstances in place, which again you'll find on the Law Society website, which cover that. But very generally, you can't act for two parties whose interests conflict. So if you're doing court actions, you certainly can't act for the pursuer and defender in a court action. Next one is disclosure of interest. And this is much like independence, but more specific. If you have a personal or financial interest in instructions your client is providing, then you need to let the client know, and also consider if you can actually still give your client independent advice when you have that interest in the background. Effective communication, this is, I would say, one of the biggest ones. Certainly the difference between what you learn at university and what you might come across in practice. Um, so many cases you might see in a disciplinary tribunal come about through lack of proper communication. It's where the solicitor fails to update clients about what's happening and the client gets very unhappy, and that can be a conduct and a service matter as well. So it's sometimes it can also be the clients thinking they're getting something they're not, our client doesn't understand your advice, or simply just managing expectations. So that's all about effective communication, and that's up to you to make sure that when you're giving advice to clients that you are well understood, and obviously you keep them in the loop about things as well. It's such a, in many ways, the easiest one really shouldn't be falling afoul of, because it just usually is a matter of picking up the phone or sending an email to your client to tell them what's happening. The ninth one is competence, diligence, and appropriate skills. This is really just you making sure that you keep on top of things. Your specialization is really the norm nowadays. So you need to keep on top of developments in your area, make sure your advice is always up to date. Professional fees is the next one. These should always be fair and reasonable. Most important is that they are clearly communicated to the client at the outset, I would say. Again, this goes back to effective communication, and you'll see there's a lot of crossover with these standards. And you make them clear to the client at the outset, usually by way of a letter of engagement, so that there's no surprises later on when you finally bill them. The next one's about withdrawing from acting once you've actually accepted instructions. The idea behind this is that if you agree to act for a client, then you can't just drop them just because you feel like it. Taking on instructions creates a responsibility on you to act in the client's best interests. There are, of course, times when withdrawing is the only option, such as your client asks you to lie to the court, or the relationship breaks down to the point where there's no trust on either side. If you just arbitrarily dropped your client, you could leave them in a bit of a mess, especially just before a court hearing, for example, and that could absolutely lead to a valid complaint. So again, just be careful that you know what you're taking on when you take on the instructions, because the idea is that you'll generally try and see them through to the end. We're almost there. The next one is the relations with the courts. All lawyers, regardless of what work they're actually doing, are considered to be officers of the court. Now, that only has a practical effect when you're dealing with the court to any degree. So I'm a court lawyer, so I deal with quite a lot. But if you're in, for example, private client, you'll be dealing with the court in terms of wills. So, it's not just court lawyers that will be dealing with them. And what this standard imposes upon you is a responsibility not to mislead the court, and also to accord the court and its staff the proper respect. So these are things that are incumbent upon you as lawyers or officers of the court. The next one is relations between regulated persons. Now, what this really means effectively is a regulated person is someone who's a lawyer or a paralegal, and so it's really your relationships with your professional colleagues. And it's important that you maintain good relations as well as possible. You don't need to be nice to them, especially if they're not being nice to you. But generally, if you give your word or you make a statement which you're trying to say this is what I'm saying has happened, then the other side is entitled to rely upon that, even if it's not such a legally binding statement. Generally, the idea is no backstabbing goes on. If you say to another solicitor, I will send you this money tomorrow, then you're expected to send them the money tomorrow, feeling which that might be a complaint against you for failing to achieve your responsibility of regulations between, relations between regulated persons. And again, that applies to other people. They should be able to, you should be able to rely on their word as well. And this element of trust that goes throughout the whole system ensures that things run a bit more smoothly than they might otherwise have done. Okay, last two. Number 14 is the diversity. Now, really, this is just an anti-discrimination standard. Essentially, you're not allowed to discriminate against clients, employees, other solicitors. For example, you can't refuse to act for someone simply on the grounds of race or sexuality. And if it could be proved that you did refuse to act for someone on those grounds, then again, that would be a complaint against you, which could result in professional misconduct. And finally, and I imagine Law Society would probably regard this in some degrees as the most important one, is a duty to cooperate with the Law Society. So when the Law Society is investigating complaints, they will get in touch with the individuals who are complained against, to ask them for information, files, etc. And it's important to everyone, and Law Society in particular, that you respond to the Law Society and cooperate with them in their investigations as much as you possibly can. Is the only way they can then understand if there is any liability on you or whether the complaint has no merit and be thrown out. So, you know, it's useful to you and to the Law Society. And if you fail to do that, then it really clogs up the wheels of investigation for the Law Society. And what can sometimes happen is you have a situation where the original complaint against the individual is thrown out, but because they failed to cooperate with the Law Society, they are still found guilty of some kind of misconduct charge. And you see that actually happening more often than you might think. So generally, you know, the Law Society get in touch with you, get back in touch with them as quickly as you can, helping with their investigations as much as you can. Okay, so it's a bit of a whirlwind tour through the 15 standards, and hopefully it's given you some background to what these are about and how these might apply to you in practice. Again, to say the Law Society website's got really good information about these, a bit more detail about, you know, things. If you're worried you've contravened one of them, you know, have a look at that, might help you. I say I'm happy to take any questions later on, but I don't want to tread too much on the feet of my co-speaker, so I'll leave it there. Okay, thank you.
Perfect. Thank you so much, Stephen. And just to say once again, I hate to ask, but can everyone please pop themselves on mute? Because I think I've tried to mute everyone, but there is still a couple of individuals that I can't get to mute, and that should hopefully help it breaking up. But if people did miss Stephen, then I am actually recording the session, so it will be back up on our website. So hopefully Ian's will be a bit better for recording. So on to our second speaker, Ian Sim, who is a consultant at Strathclyde Business and Law School, and who is also the co-author of Commercial Awareness for Lawyers. So on to you, please, Ian.
Thanks very much indeed. Good evening, everybody. We'll just jump straight into the topic of risk management. And the first question has to be, what do we mean by risk? And the answer is that risk so far has always had something of a bad press, and the general convention is that risk is inherently bad and should be avoided at all costs and wherever possible. And when I jumped on to extract a couple of online definitions, it doesn't really matter where you look. The Merriam-Webster definition is kind of classic of what you find online, and it says that risk is the possibility of loss or injury or someone or something that creates or suggests a hazard. But that's actually quite one-sided, and when you're coming at risk, and from your perspective as young lawyers, that probably the most important facet of risk management will be around anti-money laundering. But as you rise through the ranks and you start to run your own firms, there'll be a whole raft of other risks that you've got to keep in mind as well. But in fact, if you look outside of the legal profession and look into the project management profession, which is not new. Richard Susskind years ago said that lawyers can learn a lot from project managers. And you turn to the Project Management Institute in 2004, the PMI came up with a much more sort of even-handed definition of risk. And it says that risk is in fact an uncertain event or condition, which if it occurs, either will have a positive or a negative effect on your objectives. And in the case of the PMI, it was projects, but in your case, it would be a positive or a negative effect on a transaction, for example, or a client matter. So in fact, risk is not viewed as necessarily inherently a bad thing. Risk is viewed at a higher helicopter level where risk is the uncertainty. And it's that uncertainty which, if the cards fall either way, can lead to a positive or a negative outcome. Now, the reason that the PMI then focuses on negative risk, as indeed most of you will, is because in fact they found in that particular piece of research that led to the 2004 report that in fact project managers were very reluctant to report positive risk. Instead, project managers were saying that if a project came in on budget, or if the project was delivered ahead of time, it wasn't due to risk or inherent uncertainty sort of catalyzing in a positive way. It was entirely referable to their excellence as project managers, because there was this perception that positive risk could be viewed almost like good luck, and nobody wants to say that they got lucky. No, you don't want to say to your clients, the reason that we got your conveyance done on time was because we got lucky. No surgeon wants to say I got lucky when I cut off the right leg. So people tend not to self-reflect accurately when it comes to reporting positive risk. And this has been noticed time and time again across different professions. And so quite simply, there isn't a lot of empirical research around positive risk, and that's actually why most resources tend to focus on negative risk. But it is fair to say that you should keep keep in mind the fact that there is, in fact, actually a more positive dimension to it. It's not inevitably negative. So for the rest of this very short chat, we'll focus on the negative. Okay, it's a Tuesday night. Let's be negative. The only way to completely avoid risk creeping into your legal work, typically with AML, is if you just don't take on the job. And I'm going to come on to a couple of sort of whimsical stats in a short while, just to illustrate why in your lives you can't avoid all risk. In a business sense, it's simply inviable. You cannot survive as a law firm if you just simply avoid risk. And indeed, if you go back into the project management world, PMI has probably set down the classic definition of what risk management is, because that has to be the pragmatic way forward when you're dealing with clients and transactions. And the PMI says that risk management means that you firstly have to identify where the potential risk lies. Secondly, you've got to analyse those potential risks. Thirdly, you've got to plan your response. Not to every risk, but what they say are the most important risks, because actually risk management is quite an expensive thing to do. And so you don't want to worry necessarily about minor risks. And then lastly, you've got to make sure that you're monitoring the risk over the lifetime of the project, or in your case, the lifetime of the client transaction. And the goal in doing so is to increase the probability and the impact of the potential for something positive. In other words, you're trying to create an environment in which good luck might flourish. And you're trying to decrease the probability and the impact of something that's negative. And the reason those words are in red is because that's actually what we mean by analysis. So risk identification is, as it suggests, you're identifying where the risk lies. Analysis means you're trying to assess the impact that this risk will have if it becomes true, and how likely is it to actually happen at all. That's why we talk about probability and impact. So in terms of how you go about dealing with risk, the go-to resource is the International Organization of Standardization. And it has an excellent website, and it's probably the standard bearer for risk anywhere in the world. And it suggests that you look at risk across 6 broad categories: strategic, operational, financial, market, environmental, and regulatory. Now, in your case, as lawyers, a great example of regulatory risk would be breaching the AML regulations. But if I just give you one other example from that list, strategic risk, what might strategic risk look like? And I can give you a great example of strategic risk. If you, quite a lot of you will probably be too young to remember Woolworths as a high street store. I am tragically not. And when I was growing up, Woolworths was the go-to high street store. The board of Woolworths made a conscious decision to stay in the high street. It owned quite a lot of its premises, and it tried to do a little bit of everything. Things like, stationery, confectionery, newspapers, magazines, books, clothing, etc. And a couple of things then happened. There was a generic or general move to out-of-town shopping, to these massive places like Braehead and Silverburn. My ideal of hell, but some people loved going to them. And secondly, we had the huge crash of 0809, where it wasn't actually a great thing to be a business that owned its own heritable estate, because the balance sheet was just reduced in value quite considerably. And so Woolworths had a perfect storm. People weren't shopping in the high street. It had very expensive premises to maintain, and that was an example of a strategic risk that kind of went the wrong way. Okay, so if I just pop on to the next slide, just to go back to a point that I was making earlier, you have to accept a degree of risk. So before we look at what I mean by risk management, you've got to accept a degree of risk. And what's on this slide is just to illustrate a point that you can't ultimately avoid risk. So if you go back to the ONS stats 2010, 99 people managed to kill themselves falling out of their bed. 13 people remarkably died just falling off a cliff. And the one that I find most perplexing is how you managed to get yourself run down by a horse or a cow, but 7 people in 2010 actually managed to get mowed down by a large farm animal. So the avoidance strategy would be, well, I'm not going to go to bed, I'm going to just lie on the floor and hope that somebody doesn't fall out of bed, or I'm never going to go to the seaside, so I never have to deal with cliffs, and I'm not going to go to the country, so I never have to deal with horses or cows. And that becomes an absolutely absurd perspective. And so, in fact, you have to get into the mindset that we're going to actually not just avoid risk, but we're going to deal with risk. And then that takes you into the next slide, which it takes us back to the International Organization of Standardization's guidance. And it says that when, well, it first and foremost says you have to embrace risk. You can't avoid risk, because if you avoid risk, then you are avoiding business, and then you won't stay in business terribly long. So what it suggests you do is it suggests that you deal with risk across the 6 categories that I touched on earlier. So things like strategic risk, financial risk, regulatory risk. And when it comes to actually sort of putting in place a risk management strategy, it suggests that you keep the following in mind. So the first thing that you've got to do is you've got to ensure that whatever you're doing creates value in your business. Now, anti-money laundering checks will create value in your business. I'll give you an example of probably the most famous example in risk management history of something that was thought not to create value was the Titanic. You all know the story. I don't want to give the ending away, but everybody dies at the end. But 3 years before the ship was launched, they actually had designed it to have enough lifeboats for everybody. But quite simply, the owners disagreed with Harland and Wolff in Belfast. They said that they didn't think that the extra expenditure created value. And so they took the risk, and the risk went wrong. It sort of crystallized negatively, and you all know how that ended. So whatever you do, there has to be a sort of board level buy-in or executive level buy-in that the gain is exceeding the pain. The second thing is it has to be tied into organizational ethos. By that, broadly, what I mean is it has to start at the top and it has to be cascaded down the way. It's phenomenally difficult to try and do it from the bottom up. Thirdly, it very much needs to be tied into the decision-making process, and you'll be familiar with that because you won't be able to record time in a transaction until you've actually completed your money laundering, anti-money laundering checks and the paperwork that goes with it. It needs to deal with uncertainty and assumptions, which actually ties into the other point 2 down, which is that it must use the best available information. So at the very beginning of any client transaction, you are, to an extent, not going to have all of the information that you will have at the end of the transaction. So at the beginning, you have to make, you do have to deal with the fact that there is a degree of uncertainty, and you have to take, frankly, your best educated guess. In other words, you're making some assumptions. Whatever you do should be systematic and structured, and there's a reason for that. It comes down to psychology and narcissistic personalities. In fact, there's now a debate with psychologists about whether there might be narcissistic personality disorder, and typically narcissists will, if they can find a way around a rule, their ego overrides logic and they'll try and find a way around the rule. And you don't want people like that not complying with the regulations in case it comes back to bite you. So whatever you do should be systematic. Everyone should be doing it in the same way. And the rest of it's pretty intuitive and straightforward. You've got to be able to customize what you're doing. It's got to be transparent. In other words, it has to be manifestly obvious why you're doing it. It needs to be responsive to change. You need to be continually striving for improvement with risk management. And whatever or however you assess risk, you have to go back and periodically reassess the risk assessment that you have done, because risk ultimately isn't a static concept. Risk is fluid. It is ever changing. And if you go back up just to human factors, whenever you're dealing with risk, it's really important that you create an environment where you can do it properly. Human factors relates to, well, it's a whole topic in human factors, but broadly speaking, the things that will really seriously affect risk management is if you try and do a risk analysis when you're overly tired. And when you try and do a risk analysis whilst concurrently doing something else. Just very briefly, there's a study done in France which showed, using train drivers about 2001 in Provence, which showed that the impact of fatigue is actually worse than the impact of alcohol. You have to have quite a substantial amount of alcohol in order for the curve to cross over, and for you to get to a point where the alcohol intake is worse than the fatigue. So it's actually really important that you don't do your risk assessments when you're overly tired, or for that matter, having drunk alcohol. And the second thing is you shouldn't do it when you're trying to do something else, because there was 2 studies done in Strasbourg and Massachusetts Institute of Technology, which demonstrate that human performance in terms of being able to process information quickly and accurately substantially tails off right across the spectrum. It doesn't matter your age, it doesn't matter whether you're a man or a woman, it impacts everybody pretty well equally. And so again, if you're doing a risk assessment, particularly AML risk assessments, you want to be doing it in an environment which is ideally quiet and not going to have interrupters, which will have the impact of essentially forcing your mind to multitask. You want to make sure that the actual landscape is conducive to the risk assessment. So those are the broad principles. Then you've got to think about how to identify risk, and there are 2 ways that you can do it. Most law firms will use source analysis rather than problem analysis. A source analysis is quite simply as it suggests. You're looking at the overall source of risk and putting in place a set of sensible policies to deal with the source of risk, rather than trying to identify potentially hundreds of problems. Now, you should get the same net outputs whether you use source analysis or problem analysis. It's a bit like having a bucket full of paper. You kick the bucket over and you cascade hundreds of bits of paper. Problem analysis is where you're trying to pick up all the bits of paper and deal with them. Whereas if you can control the bucket, then it should have the same net outputs. The big advantage of source analysis is that, as I said earlier, risk is always changing. And things, particularly with money laundering, over my career, money launderers have evolved the way in which they target law firms. And if you've got a great set of robust strategies around the source of risk, then as the risk changes and evolves and new methods of defrauding other people come to bear, then your existing strategy should be enough to pick them up. That's really why you want to go back, and that's really why you want to use source analysis relative to problem analysis. Once you've identified what you think the key risks are in the transaction, you then have to assess it. And it's always done in terms of impact and probability. And you normally will use a score of 5, but it can be whatever score you want, so long as it's done the same way across the board. But the easiest way is just doing it out of 5, and so you would allocate a score for probability or probability of occurrence out of 5, and then you would allocate a score for the same thing in terms of impact. And then you can do it 1 of 2 ways. You can either multiply them together to give you what we call the risk magnitude score out of 25, and then from that score, your firm will have a policy. It will, for example, everything above 20 is regarded as high risk or too high a risk, and we're not going to do it. And the problem with that is, again, back into different personality types. And sometimes when you get numbers that are, if I can use the pun, binary, you end up with people rerunning the numbers to essentially bring the score under the cutoff that it's the starter for the policy kicking in. So sometimes it's better not to use numbers, but to use the same concept. I'll just click into the next slide, and instead actually put all of the numbers into a graphical form. It's what we call a composite risk index, and it's dead easy to understand. If you have, for example, something that's very high risk, then it would be a 5 and a 5, because it'd be high probability, very serious impact. And so you'd pop that up at the top right-hand side. Conversely, very low risk, bottom left-hand side, and anything in the middle obviously would go in the middle. And the nice thing about that is that you can actually shade, well, 2 things. Humans are actually kind of graphical creatures. They do better, broadly speaking, with images than they do with hard data. Secondly, it allows you to shade things. So people who are in that sort of personality category where they might fly the envelope are less likely to try and push the envelope because it's not a hard and fast choice. So that's why it's a great idea to stick it into graphical form. So once you've identified and plotted where you think the risk lies in terms of probability and impact, you can then start to have a look at the sorts of things that you might like to try and achieve with your risk management. So let's pop into the next slide. And broadly speaking, I don't know if you can see the arrows. What we're trying to do when it comes to implementing a practical strategy is one of three things. You are either trying to reduce the impact, or we're trying to reduce the probability, or best still, we're trying to reduce both impacts and probability. And you can see the effect that it has. You're basically trying to take the numbers that are in the top right, and you're either moving them to the left with impacts, or you're moving them down in probability, or you're taking them down on the diagonal, both on impact and probability. You're not going to be so concerned with the stuff in the bottom left because you've already assessed that it's not likely to happen, and if it does happen, it's not going to have much of an impact on your firm. The real focus is on getting the numbers that are in the top right into the middle to the sort of amber area, and the ones that are amber into the green area or the green green quadrant. It's not imperative that you get it down the diagonal. So, for example, if you step into the aviation sector, aircraft manufacturers typically don't tend to try and reduce impact, but they work very assiduously in reducing probability. If an aircraft breaks up at 35,000 feet, it's going to be a terminal event. So what we're trying to focus on is making sure that it doesn't break up at 35,000 feet. So a lot of the focus in the aviation and maritime sectors is not actually trying to reduce impact, because the impact is always going to be catastrophic, but we're trying to massively reduce the chances of it happening. And that's a perfectly legitimate strategy. So it's still a win if all you can do is reduce the impact. It's still a win if all you can do is reduce probability, and it's a win-win if you can do both. And that leads us into the next slide, which is just very quickly, what are the strategies that we can employ? Well, you've got avoidance, reduction, risk sharing, and risk transference. And I'm going to just explain each one in turn in the next slide. By risk avoidance, I mean quite literally that you don't do the activity that carries the risk. And that does mean inevitably that you will lose out on potential gain. And this will really come down to your firm's executive boards or partnerships view on risk. And different firms will have a different appetite for risk. Just because something is incredibly risky, there's another thing that you should know about risk. Just because you've assessed it as being very risky, both in terms of impacts and probability, it doesn't mean that it's actually going to happen. I mean, I say to any cohort that I talk to you about this subject, I could drive into Glasgow every day on the M74 at 90 miles an hour, blaring, whatever music is in the top of the pops, well, that doesn't exist anymore, at full volume, and never get caught by the police. I could also amble in at 60 miles an hour, transiently go up to 70 and get nicked by the first police car that I come across. So actually, in terms of measuring actuality, there are some real challenges around that. So just because something's very risky doesn't necessarily mean that it is actually going to happen. And there are lots of examples of businesses that get involved in very high risk activity. In particular, in Scotland, we call Weir Group, big engineering, massive engineering company. We had a lot of money over in some war-torn countries as they're in the process of rebuilding, even though there's a big risk to physical safety going out there. But the correlation is that you get a huge amount of gain if you take on the risk. So it very much depends on your firm's attitude, whether you're going to avoid it or not avoid it. But there will be some sort of avoidance strategy within your firms, and you should probably ask your partners, what sorts of transactions do we just not do. The more likely solution will be risk reduction or risk management. That's where we're putting in place some sort of pragmatic strategy to reduce the impact or the probability, or both. We also can look at risk retention or transference. That's something that you don't get so much of in the legal world, although to an extent you do it because you're obviously underwritten, you have insurance and indemnity, but it's something that you're very familiar with when you drive your cars. You transfer the risk of driving your car to your third-party insurance company. And the fourth strategy is simple risk retention. I said much earlier on, you can't control every risk because risk management is actually quite expensive. So it's not a good idea to be spending a lot of your time and money on trying to control low impacts and low probability risks. So you would simply accept them. And then the last thing I want to say is that once you've done all of that, you're so probably on the next slide along, I think, or sorry, my final slide, you'll be glad to hear, you want to have a risk management plan. And the risk management plan for every law firm should include a short summary on the particular technique that you've used, whether it's composite risk index or another technique for risk identification, and it should outline who is responsible for doing the identification and the analysis. It should have some sort of monitoring policy and control policy. So, for example, we check files every week, or we check files once every 2 weeks. It gets signed off by the board, and it is reviewed regularly in light of two bitter things: experience, which is never usually wonderful, and actual loss, which is even less good. Anyway, that really is those are the nuts and bolts of risk and risk management. And I think, wrap it there, and I'll pass you on to the next speaker.
Perfect. Thank you so much, Ian, and for those interesting stats and assessments there. So finally, we have Susan Williams, who is part of the oversight team and a best practice advisor at the Scottish Legal Complaints Commission. So over to you, Susan.
Sorry, okay. Yeah. Right, am I sharing the slides yet? There we go. Sorry, please just bear with me a second. I think you might need to stop sharing so that I can.
Yeah, I think your screen's a bit delayed, so just try again, Susan. There you are.
Okay.
That's perfect.
Okay, fine. So thanks very much for the invitation to join you, just to give you some ideas about us and what we have, some trends and tips and best practice about complaints. Now, obviously, as you know, the main function of a legal regulator is practitioners do meet high standards that are expected of them. The SLCC is one of the 5 legal regulators in Scotland, and here they are. I'm not going to go through it in any detail. Unlike the others, we aren't a representative body. You'll see us on the extreme right. We were set up under the Legal Profession and Legal Aid Scotland Act, which has quite a strong consumer focus, as an independent and impartial body. Now, we're commonly described as the gateway for legal complaints, and that simply means that a complaint against any Scottish practitioner has to be directed to us in the first instance and will only be investigated if we decide that it's eligible for investigation. I'll explain that in a second, but I'd just like to tell you why else I'm here today, and that's because we do actually have other functions, which is a summary there. I work with our oversight and outreach team, and we correlate and analyze the data that we get from complaints, which then enables us to give guidance to the profession to help them to understand, to deal with, and to avoid complaints as far as possible. And I've got tips on that later. Now, I said I'd explain that gateway function. There's quite a lot of misunderstanding and criticism about our approach, like why do we accept complaints from third parties and why don't we charge for complaints? And there's a short answer, which is the 2007 Act is very prescriptive, not only about our functions, but also about each stage of the process that we have to follow. You'll be aware of the Robertson Review and the consultation process about the future of legal regulation. We don't believe that our Act is currently fit for purpose, but we are bound by it until things change. It is a very brief overview of our process, in which the first 2 stages are the gateway function. Any complaint about a Scottish practitioner must be within our jurisdiction, which means not only that it is against a Scottish practitioner, but also that it's about legal services. But complaints don't come as a surprise, because they must also be first made to the practitioner, allowing at least 28 days to address and hopefully resolve the concerns. And our guidance publications actually then give you pointers on how best to deal with complaints at this stage. And as the second step in the gateway, we check whether the complaint has been made within the prescribed time limit, which is 3 years, and what the complaint is about. Now, this is not an investigation. We don't have the file. We can't determine at this stage whether what's complained about actually did happen, because that comes in at the later investigation stage. The bar for deciding that a complaint is eligible for investigation is low. All that we need to be satisfied is that the complaint indicates a potential breach of a defined conduct rule or a defined service standard. So a complaint that says that a lawyer refused to let a third party see his client's instructions doesn't breach a rule, and it won't be eligible. However, a complaint that a lawyer has acted where there's a conflict of interests does, as Stephen indicates to you, get covered by a specific rule about conflicts, so it will be eligible to move to investigation. And at investigation, the file will be obtained, and that will determine whether there was indeed a conflict. Now, I just referred to a potential breach of a defined conduct rule or service standard. Now, Stephen was mostly speaking to you about the rules, but the service standards actually sit alongside. When someone makes a complaint, they're essentially upset either that the legal work wasn't done to their expectations, and that's a quality issue about the service, or they're upset about how the lawyer worked or made them feel, which is a focus on the practitioner. The 2007 Act split the investigation of complaints so that conduct complaints, those covered by the practice rules, are investigated by the representative bodies. In your case, these are the Law Society rules, obviously, but complaints about service provided by firms are investigated by the SLCC, and I will include a link to the full breakdown of those standards. Now, you'll notice that the 14 service standards include concepts that are also in the Blue Conduct Rules, and indeed there isn't always a clear distinction between rules and standards. And as part of the gateway function, we have to decide if each of the elements or issues of the complaint will be classified as service or conduct. It's not always easy, and it is very fact-dependent. But now that classification makes a difference to who's named in complaints and the potential outcomes, because conduct complaints are framed against individuals. There's no possibility of settling them once they're accepted as eligible. Service complaints name the individual, but they also name the firm, and in practice, the firm is the one that deals with that. And of course, as Ian's just been talking about the risk, that is where the firm will make the decision on how they might wish to resolve them at any stage. Our investigators working at any stage of our process always actively identify and encourage the potential for resolution. And in fact, the third stage, which you will have seen of this process, mediation, is a free mediation for service complaints. Now, here's a summary of the potential outcomes. I'm not going to read it to you, but you can see that in keeping with our resolution aims, the SLCC is primarily focused on awarding compensation, not sanctions. Other regulators do impose sanctions, but they can also award compensation, but at a lower figure. The only thing is that if a complaint goes all the way through our process and is finally upheld, there is a risk there that the firm will be required to pay a complaints levy of up to £5,000 on the polluter pays principle, offset some of our expenses, and that is a really strong incentive to seek resolution. Now, I won't say any more about the process now because you've got that brief summary and it is explained in our website. But let's have a little bit of a look about complaints. Now, what is a complaint? Actually, it's not as obvious as you may think because this is what the Act says. So they don't always reach you neatly packaged and labeled. Something like, I didn't understand, or you haven't answered my question, or I'm really surprised. Could well be a complaint, so you should please watch out for and deal early with these kinds of concerns. Now, why am I suggesting that you as young lawyers should take action on a complaint? Isn't that really for the client relations manager who gets appointed in terms of Rule B5? Well, it's ultimately up to the firm to decide how it wants to deal with the complaint, and that's part of the risk assessment that they do. But remember that you have a vested interest because you will also be named if the complaint isn't settled in the firm and is made to us. Now, I'm not sure how many people on this call are trainees, but very briefly, if you haven't yet been admitted, any complaint about your work or conduct will name your supervisor. If you have been admitted, both you and your supervisor will be named. So please don't ignore or shy away from a potential problem, as it can have an impact on others. And even if a complaint during your traineeship is not upheld, the Law Society still requires us to report it to their admissions department. And finally, perhaps the most compelling reason that I mentioned you dealing with a complaint is that the best way for you to avoid complaints is not to be complacent. Understand and learn continuously from any expressions of dissatisfaction. Now, who potentially makes a complaint? Well, the Act, the rules, and the standards all note that they can be made not only by your client, but also non-clients or third parties, and these can range right through from presiding officers to opponents to witnesses, or to anyone else affected, such as a beneficiary in an estate where you act for an executor, or a company director where you act for the company. Third-party complaints come with their own complexities, not least your inability to disclose what your instructions were, but they do have to be dealt with. You can't ignore them. Now, from our stats, we know that 6 business areas attract the most complaints. This is not really surprising. They form the largest percentage of most firms' work. They involve serious financial and emotional implications, which makes the clients hypersensitive. You can't change this, but you can be aware of the risks in this type of work and consider where and how to minimize the chances of things going wrong. But the most interesting statistic is this one, and that's the subject areas of complaint. The trends for service complaints are shown in green and the ones for conduct complaints in blue, and they follow the same pattern. It's actually not the hard legal knowledge and skills that cause the most problems. Most complaints are to do with soft skills, and poor communication, as Stephen mentioned to you, is the number one reason why people complain and why their complaints are upheld. And that is perhaps my biggest takeaway message. So now your burning question is, how do I avoid ever having anything to do with the SLCC? It's hard not to be liked. However, you've had a talk on risk, and complaints are, first and foremost, a business risk. Your clients are humans, and with the power of speech comes also the power to complain. We know that everyone is likely to be named in at least 2 complaints during their professional life. The Act speaks to reasonably competent service. A person who achieves the 100% perfect balance between journey time, fees that make the client happy, faultless communication, and outstanding outcomes is probably also the person who's commuting to work on a flying carpet. It doesn't happen. But now let's look at some of the tips. Now, I want to give a disclaimer right up front, because none of this is rocket science. It's really a reminder of some common sense principles. But from my experience over quite a few years, it's often the simplest and most avoidable things that can escalate into the worst problems. So let's picture a typical lawyer's office. You've got a pile of work, all urgent, all in high-risk areas. You aren't sure of the firm's policies or systems. You have a mountain of phone messages and calls who are convinced that they are your only client. Which should you prioritize? How many hours should they take? Unexpected events can crop up, personal or work. This makes you worried, stressed, overtired, and your tweet has gone viral, and you're sure that there's a mistake just waiting to happen. An explosive situation. But let's break it down. I mentioned thinking about the risks attaching to types of work, so plan for time limits, prescriptive periods, and lodgement dates. Memory is never enough. Check, double check, and diarize. Remember that you can seek professional guidance from the Law Society's professional practice team. Find and read the firm's policies, especially their complaints policy, and if there are any systemic issues, make sure they're tackled up front. I've said here, try to be realistic about the workload, and I know that's hard if you're a trainee or young solicitor, but you can remind your supervisor that they too can be named in a complaint if you aren't coping, and complaints take up unbillable hours. Time management is a vital skill, and that includes blocking out time to plan. Along with an increased service design approach, many practitioners are now advocating a project management approach, something that Ian has spoken to as well. And this works particularly for areas like conveyancing that tend to follow a more linear pathway. Now, office automation and AI can be great for managing your time, but please be aware of the pitfalls too. They don't substitute for proper proofreading, ideally by a second eye, or proper thinking about the consequences. We've really dealt with a lot of complaints about not and now switching places or jumping off the page altogether. It sounds obvious, yes. Are these real cases? Oh, yes, they are. And on the personal side, take a calm moment to figure out what your personal triggers are and also your own favourite avoidance or procrastination topics. The Scottish Public Service's Ombudsman has some excellent pointers for difficult client conversations. Please also read the Law Society's December 2020 guidance on social media. And remember also that other help is at hand. So that's a general overview. Do I have any more specifics? Well, yes, both from our own research and Solicitors Regulation Authority study in England, we do know what clients are looking for in a healthy professional relationship. Okay, they're firstly looking for your commitment to building a genuine relationship of concern for their needs. They obviously expect the highest integrity, and that actually goes further than the rules. Also have the honesty to admit if you don't know the answer, but we'll find it out, or that something's gone wrong. You've heard already tonight that you may have to tell a client bad news. Don't put it off, and do be prepared to discuss a solution to deal with it. Clients want to know about costs. And what was interesting from the SRA study was that the practitioners had said that they did provide clear information. The clients to whom they provided it said it actually wasn't that clear. And surprising to many, clients aren't swayed only by a good outcome. They do want an explanation of the legal process. Now, there's one thing that enhances and grows this relationship, and that is effective communication right across the board. It's really unfortunate that so many complaints do come from poor communication, given the number of opportunities that you have to get it right. It starts by explaining to the client how long their first appointment is going to take. If there's a charge, what documents you need. Terms of business shouldn't be a tick box exercise, but a strategic tool to explain what you will do and what you won't do. For instance, you might handle the purchase of a retail liquor business, but you won't handle the licenses. And for everything that you do, from telephone conversations to complaints discussions, please keep full and excellent file notes. I've even seen some solicitors ask clients to sign those as confirmation that unwelcome advice was given but was heard, or to confirm instructions that they have given that the solicitor is maybe querying. Now, on communication, plain language is not patronizing. It ensures clarity. But truly effective communication isn't just how you speak, it's also how you listen. Can you pick up nuances? Can you ask the right questions? And even more important, can you get strong feedback from clients that will allow you to pick up any doubts at the earliest opportunity and thus avoid complaints? Find out what clients think of the progress. Find out why the client has suddenly stopped paying monthly. What's gone wrong? Remember the project management approach that I mentioned? Well, the key stages there in your project plan are also excellent points at which you can seek feedback to check with your clients that you're still on the same page. Think about whether you're getting the same questions over and over. Does that indicate that you may need to change up how you're dealing with people, or when you're returning calls, or what information you've got on your web page? Do you stick to your commitments, even if you think a call on Monday instead of Friday won't make any difference? The ability to actually preempt the problems eliminates the need to deal with a complaint later, and that's good news for your time management and your costs. Now, I've also included a link to our guidance page, which is going to be updated over the next few months. And there we traditionally suggested the 3 points for good handling of complaints or queries in the firm. But actually, I think that they apply just as much to any communications with clients. And that's engage, explain, and respond. It's possibly worth going back and thinking about these again from time to time. I'd just like to say that we genuinely do appreciate the stress that can follow if you've done everything by the book and a client still complains. We are absolutely aware of the emotional, reputational, economic, and time risks that are attached to complaints. People complain for various reasons, personal, subjective, and objective, and sometimes they only complain to the SLCC because they want a second opinion. Never discount the value of expressing regret that somebody's been upset by your actions. And remember, a complaint does not signify the end of a relationship, because those who complain are often the ones giving you the chance to repair the relationship, and at least they aren't talking to social media. But even more importantly, the fact that a complaint is made is not shameful, unusual, or even negative. We know that every lawyer is likely to get at least 2 complaints against them during their practicing life. And every complaint offers a learning opportunity. And if you genuinely take the opportunity to reflect on what you can improve and then do so, it's a contribution to your own development and managing your future risk. And finally, through your professional life, we'd encourage you to stay in touch with your regulators, and here are some links for you. While we at the SLCC can't give you the type of specific advice that the Law Society can, we are more than happy to advise you on process and good practice and to get your suggestions and comments. There are our details, and thanks very much for your time.